This was a wonderful evening because it has thrown light into many of the significant areas of a legislation, which in fact need to be addressed with all significance, importance, sensitization, and so many other things. I just run through taking 3 or 4 minutes. I'll just run through the output generated by our resource persons. Kamlesh sir, in fact, had indeed done a forensic analysis where I think that whatever points that you have raised, indeed, is reflective of the real-time issues faced by any organization which has to grapple with a sexual harassment complaint. Whether we are legally trained, whether we are not legally trained, whether we have got a compact organizational backing, whether we are in an informal sector, cutting across all those things, even the most qualified of the organization, most significant of the organization, when it comes to handling ICC complaints, are so much brittle, just fall into pieces. Maybe because of so many things that you have raised here, sir. Particularly, the professional touch indeed is very, very important because learning and understanding the provisions or the import of the legislation is very, very important. What is your power? What are the methodologies that you have to embrace, that you have to keep track of? In what way you have to translate the intent of the act into when you deal with these complaints? How well you treat the complainant, the persistent power equation in your organization, wherein a hapless victim finds it traumatic to come before an ICC, or the perennial trauma that the institutionalized trauma that she can face even while facing an ICC, mainly because of the fact that the ICC is not sensitized. That is one aspect. The constitution of ICC itself is I think it's a lot of things. It leaves behind a lot of things, particularly the hostile environment, persistence of a hostile environment in the workplace, which may reflect upon the constitution of ICC or even the mechanics of ICC is yet another aspect, that's another thing. Then right decisions to be taken at right point of time is yet another aspect. Then powers of civil court, as you have said, except for calling for attendance and all these things, whether in the other remedial aspect, how far that powers of civil court is conspicuously missing as far as ICC is there. Whether ICC can take a factored approach, that is another aspect. Whether you are competent enough to take a factored approach is even more a greater issue. And how exactly applied remedies are to be given. And also the constitution of ICC, the cross-section of the members constituting the ICC is also, I think it leaves a lot to be desired. So all these things go to the intrinsic matters as far as the mechanics of this legislation is concerned, where we need, whether you are an organization, whether a governmental organization or whether a private entity, you need to be continuously trained in all these things. And then only that sensitization should come from within that particular the mandate of that legislation. That is one thing. And along with that, what John had said is also very, very important. Ad hocism is the major issue, because I don't think even now, even when we deliberate upon this particular evening, we can come across a fair number of institutions which does not have that wherewithal of ICC. Or some cosmetic mechanism that is being put in place. And only when a complaint is raised, then you will realize that, see, your house is not in the order, and you find it very difficult to come into terms with the demands of the legislation, and you fall into pieces, giving rise to so many other controversies. So that again is one of the what both Kamlesh sir has cited as well as John had cited, has got a mirror image as far as our institutions are concerned, whether this belong to government or whether this belong to yet another sector. That's why the suggestions particularly given by Kamlesh sir is it goes deep into the efficacy, to raise the efficacy of this particular act, the impact of this particular act. And also John, who had suggested, wherein he had suggested a relook into the provisions of the Act. And another important aspect that he had cited was the responsibility that as a nodal agency, KELSA or DLSA has to give the victim assistance at different phases. Because once the victim files a complaint and then is being handled, I don't know whether it will be fairly handled or not. Victim is reduced into or shifted or rather pushed into a lurch wherein she finds herself lost everywhere, because the hostile environment is always there, the persistent power equation that the victim has to face. That is also very, very important. Then what J.H.K. Joseph stated, he went deep into the psychological reasons. Obviously, the rationalization of the things that happen in an organization, as well as the priorities that the organizations have to set, or the reasons, whether it is aggressive masculinization or male dominance, etc., etc. But again, that culture of coexistence and culture of that should be there in co-working between male female entities. I think that is very, very important, particularly when we are after globalization, the work culture has totally changed. Then even after 6 o'clock till 6 a.m. we will be having working time. So particularly in the technological, in the soft, in the parks, industrial parks, as well as the techno parks, etc., where time and space doesn't have any meaning whatsoever. So where you will be pushed to new frontiers of working environment, where we have to be conscious about our responsibilities and our commitments towards our fraternity. So there again, the institutional readiness and institutional preparedness when we adopt for such sort of working schedule, I think that again is a thing that is to be taken into account. Where his suggestion regarding legal education at school level, so that to understand as to in what way you have to take your peer, whether it's a male or a female, or even more greater suggestions that he had stated as to whether who should be, whether it's to give an information on this thing or to motivate to come whenever an injustice happens, raise your alarm, raise your voice, and embrace the mechanisms of remedial mechanisms, so that you yourself can redeem yourself of that situation, as well as be inspiration to other similarly circumstanced individuals. So all these things I think carries importance. Another one was Taji, in fact, was more linked to anchor to the strength of these legislations. Obviously, she had thrown light on the filing procedure, etc. Whereas John, on a contrast, had cited about the cumbrous nature of filing procedures, and also the uneven-handedness in the matter of filing procedures, which lands the victim in a difficult situation. Obviously, these are all contrasting pictures. And Taji was giving the suggestion regarding the fact that the scope of sexual harassment to be widened, where all gender discriminatory practices happening in an establishment need to be accommodated, need to be defined within the scope of sexual harassment, which again we need a larger discussion, because the semantics matters. Whether all gender discriminatory matters can be brought within the scope of sexual harassment, that again, not only the semantics, but also conceptually, we have to ponder a little more on that. And the post-incident assistance, which she had, incident assistance that has to be deliberately given to the victims, then the responsibilities to be mandated to the organizers, in fact, which has got the color or a shade of a preventive mechanisms. So all these things have been mooted by Taji also. Reporting also is one particular aspect. So let me, I really feel that, see, there is something called the differential treatment that is being meted out, particularly in institutions, whether it is organized institution or whether it's the informal sector, where John had effectively pointed about a serious lacuna that is prevailing, particularly when if something happens to a domestic worker who is not subjected to any ICE, or who has got who do not have the luxury of approaching an ICC, who will be the mercy of the LCC, that's the local compliance committee. Again, she finds it a little difficult in terms of getting a remedy. And the lack of assistance, continuous assistance that is being given. So the constitution of the complaint mechanism, whether it is the ICC, whether it's the taluk level compliance committee or the local level compliance committee, leaves a lot to be desired. I think this is a classic instance where a much needed legislation, a legislation which has come into effect because of a synergic effort from the judiciary on the first note, then carried forward by the legislature. And now when this is being applied in its true color in the working sectors, in the labor market, whether it is organized or unorganized, then obviously in the functional color or the functional analysis, every legislation will have certain difficulties that it may come across. So how to redress it? So there is no single answer to redress it. Only thing is that continuously we have to engage in the literacy regarding safe working environment and also the gender security aspects, which are the pillars as far as the safe working environment is concerned, and also to proactively approach these things. But one last question, one last area of concern that I just can't resist without asking is whether I don't know whether the fraction of the judicial officers who are present here may relish that question. But for a layman like me, even the constitutional the constitutional functionary bearing that implementation, that the constitutional status and the institution which we adore as the sentinel on qui vi on fundamental rights, whether they could effectively reflect a proactive stance when some shadow was there, particularly in the shape of these sort of allegations. So that leaves behind a question whether, irrespective of the stature of the institutions, irrespective of the persons who are placed on the other side, see, the institutions have to pull their socks and come out with plausible remedies, and also to create and also to reflect that justice should not only be done, but justice it should be manifestly seen to be done. So whether it is done, whether it is furthered by the government agencies or judiciary, or whether it's an informal sector, we have to do justice to the mandate of the legislature, because it is so much anchored to the avowed constitutional values. So I think particularly KELSA and DLSA, for us, the educational institutions, especially the law colleges, have to be very much bothered, have to be very much conscious about our role in disseminating, not only in disseminating information, but also to give shape to a training force wherein we can continuously educate not only ourselves, but also other institutions and other sections of the society about this need, because the collective effort is what we need in bringing out the best of the possibilities of these type of legislations, because this is something that can have a deep imprint on the various facets of gender justice. Particularly, we have got so many the collective consciousness generated by international jurisprudence confluences with the legislations, domestic legislations. So I think with all the judiciary, the educational institutions, the government, and the layman and the NGO have got a task at their hand, and we cannot sit quiet after deliberating for 1 hour or so, but we have to take the follow-up measures. And so each one of the deliberations given by the resource persons this evening commands, in fact, demands a better comprehension of things on an independent note, whether it is to enhance the impact and enhance the delivering capacity of this particular legislation. I think that's what we have to do. Unfortunately, we do not have the time to accommodate the queries. What the organizers have instructed me is to pass on the information that any person who would like to to respond to the analysis as well as the deliberations of the resource persons, they will be provided the email so that they can continue this dialogue in the days to come. And so let us look forward for forward-looking programs as a follow-up measure, so that we have got a task at hand to contribute, to continuously contribute to enhance the capability level of the delivery of this particular legislation. That's what I have to say. Thank you. I thank all the resource persons for giving first-hand informations. Many of those informations that you have given were really fresh informations, which in fact have enlarged the insight of myself as well as many of the members or participants of this particular program. I thank LGRF and KELSA and my own institution, who could join party with the other institutions for contributing in our own way in these sort of productive exercises. Thank you.
Hi all, I hope that I'm audible. As wisely quoted, all good things must come to an end. Thus, before we draw curtains to today's program, myself would like to most sincerely render a vote of thanks to all of you present here today. Firstly, I would like to thank Honorable Justice Shobha Anama Igdin ma'am, respected Nisar Ahmed sir, Dr. Bindu ma'am, Dr. Indra ma'am, Dr. Gifty ma'am, and Dr. Palichal Pramod sir for being a part of our program. Nisar sir, Bindu ma'am, and Gifty ma'am have been with us throughout in conducting this program without a hitch. We look forward to having more future fruitful interviews with you. Thank you so much. We're extremely grateful. Thank you, ma'am. Thank you, Nisar sir. We're extremely grateful to have had such eminent personalities on board as panel members for today's discussion on sexual harassment of women at workplace. Kamli sir briefed wonderfully upon the scope of development of the Act, the Internal Complaints Committee, and compensation. Thank you, sir. John Burgess sir rightfully painted out the lacunae in constituting the Internal Complaints Committee and other drawbacks in the same. It was indeed very insightful, sir. Jayesh sir touched rightly on all notes on the societal and behavioral aspects with respect to the implementation of the Act. It was so wonderful, sir. Taji ma'am's talk spanning over the three aspects of Sexual Harassment at Workplace Act was indeed very engaging. On behalf of all of us, I would like to thank you for providing us with a deeper understanding of the nuances of the issues at hand. Once again, thank you all. Girishankar sir deserves an entire round of appreciation all for himself. We thank you for having the best moderator we could ever ask for. It is always mesmerizing listening to you, sir. Finally, a huge round of applause to all of you present here. We're indeed much fortunate to have such a wonderful participants. We hope to engage with all of you in our future interviews too. Once again, thank you all.